about what we're talking about. It is pretty straightforward. I should mention, and I wanted to just talk real briefly about sort of the political framework of what we're trying to change and where we are politically, and then Kathy's going to get to the nuts and bolts of actually how we're going to try and move this legislation forward here after this. The technology really has utterly outstripped the statutes at the state and federal level, and it has outstripped the jurisprudence in the courts at the state and federal level, to the point where really there is no governing standard or really anything by which anyone can judge how you get this information at the moment that anyone can really put their finger on. In both the state statute and the federal statute, you can get 5 lawyers in the room and get 6 or 7 opinions about what the statute means, because it's incredibly convoluted and confusing. It uses terminology about technology that's often 30 or 40 years old, and really makes absolutely no sense in the era of email and cell phones and high-res video and all the things that we think about today. The federal statute was written in 1986, and I believe the state statute was written in 85, and really have not been significantly updated since. And so when you think about it, that's before email, really. That's before, certainly before it was popularized. It was before the web. And so statutes written then could not have envisioned what our technology has become. Last session, the Texas Electronic Privacy Coalition suggested 2 pieces of legislation. One is the cell phone location data, warrants for that cell phone location data bill that we're still trying to get now. The other was to require warrants for cloud-based content and cloud-based email, like your Gmail account. It turned out that thanks to a loophole in the federal law, that after 6 months, any stored email in your cloud-based account was considered abandoned by statute, and therefore the feds did not have to get a warrant to access it. And the Obama administration fought this bitterly right up until the federal court shut them down, and because the federal courts began to agree with that first third court appeals ruling, they simply stopped appealing it. So we don't have a definitive court ruling, but de facto the feds now require a warrant, and Texas, with that legislation last session, became the first state to require a warrant for cloud-based content. And keep in mind, the feds only make up maybe 5%, say, of the total criminal cases out there. The state and local law enforcement make up the overwhelming majority of law enforcement actions. So when you govern state and local use of these technologies, you're really getting the overwhelming majority of uses out there. So what we have left is the location for cell phone, or warrants for cell phone location data bill. Brian Hughes carried it last time in the House, and Craig Estes and Juan Hinojosa carried it in the Senate. This time I'm certain Brian Hughes is going to carry it again in the House, and both Estes and Hinojosa are figuring out what they're going to do, and God knows how the Senate works. It has mysterious ways, but I'm confident that one way or the other we will have a solid sponsor in the Senate as well. And the politics of this bill, just to close out, are really incredibly favorable right now. When we brought this bill last session, it was before anyone had ever heard the name Edward Snowden. And our first and most laborious task was to convince people that this was actually a thing that they should care about at all. And people like John Whitmire would say, well, I've never heard of anybody, complaining about that. Why should I care about that? I don't know. Are they really doing that? Well, they were, but it had not been publicized. It had not been widely reported. And once, no one really knew the word metadata in the context that we all think about it now. And once Edward Snowden broke the ice, I think public opinion just rapidly shifted our direction. If it had happened 2 months prior to when it did, we would have passed this bill before. And even without the Snowden piece, we still ended up with 107 joint and co-authors on this bill in the House out of 150. So it had overwhelming support in the House. When it passed as an amendment, it didn't end up making it through, but it passed as an amendment 126-4. So the thing has overwhelming support if we can just get it before, get it onto the floor. I think the Senate looks a lot more favorable. We only have to get 19 votes instead of 21 now. And so, you know, all things considered, I think that this is about as favorable a moment as we could have for this bill, and the iron's hot and time to strike. So if anybody has any questions, probably.
So with the email, if I email someone in another state that doesn't have the warrant requirement, does that mean that law enforcement in another state can get access to my cloud-based email?
Conceivably,
You
again,
can certainly get access to your email that you sent to your friend, which is probably still sitting in their inbox, scrolled down for 6
They
months.
definitely have access to your friends.
Yeah.
right. Now, again, the federal law, which a lot of states like Texas, basically reference the federal law, which is just like Swiss cheese. And referencing that standard is sort of, they're out. So you'll see some that even say it has a warrant, but then they say, or by federal law. Well, federal law is this very low standard over here. So you would have to know what the other states' laws were. And again, the federal courts have been getting more restrictive in the last 2 years, even since this last session, you know, on email. So that jurisprudence is evolving really, really quickly, more quickly than the cell phone stuff. People pretty much understand that content is something that you should need a warrant protection for, and everyone latches onto that. Nobody wants anyone reading their emails. It takes a little more explaining to tell people why they should care if their location data is revealed. But anyway.
Even though if you ever saw a map of your location data, like Google, if you have an Android, you can see the map of everywhere you've been on your phone. It's actually quite remarkable. It's like a moment of
It knows places you've gone that you've
that
forgotten.
you've forgotten. It knows everything.
Would you have a question?
Yeah, so back to the interstate question. So obviously this only controls what happens in Texas for now, but back to your question, I remember you or one of the other speakers last time said, what Texas does, other states eventually are persuaded by.
Yes.
So we start here and maybe we get there.
That's
Right.
right.
I think that's right, and especially because Texas has all of the hardest use cases. I mean, we're right next to the Mexican border. We have, you know, cartel thugs in Houston, and we have, you know, human trafficking in South Texas. And so, you know, if Texas law enforcement is able to demonstrate that it can do its job, you know, with a warrant requirement, and I firmly believe it can, you know, nobody wants, you know, child trafficking to occur. No one's that's not what's going on here. I think they can do their job, you know, under these strictures. And once they show that, it does make a difference. Our law enforcement and our correction system is considered sort of the conservative bellwether. Just like you see the right on crime, you know, sentencing reduction movement that started here in Texas, catching on elsewhere because, you know, within the conservative movement in particular, Texas, you know, is a major opinion leader, so.
So will this warrant apply to federal law enforcement or NSA or FBI, or
Nope.
is it just Texas law enforcement?
Just state and local in Texas.
Which
So-
is the vast majority of arrests
Right.
and prosecutions.
Absolutely. So for instance, like the Austin Regional Intelligence Center, they are kind of an arm of APD, a fusion center,
Yes.
but they also get their information from, you know, it's a series of
Yeah.
different enforcement agencies, and they can still feed that information to APD. So is there anything in that bill that would prevent them from doing that? Because they don't require any kind of warrants when they're searching, and they can get the information from the federal government as well. So if there's like a political dissident, and they become on the radar, it'll feed the Austin Regional Intelligence Center this information, this geolocational information that kind of creates a profile on people, and then they can give that to APD. Has this bill, have you guys thought of this? Or?
Well, we cannot restrict what the feds do. And so when the feds and state have an interaction, you know, if the feds want to give the state information, that's something that when you get into the nuts and bolts of how functionally, you know, through a legal process in a statute, do you restrict that? The state doesn't really have that authority. The Fed is allowed to communicate that. And so a lot of those, you know, it's very similar. Anytime there's other examples like the HIDTA task forces, the high intensity drug trafficking area task forces, where you have these state and local, and there's always possibility that somebody who works with somebody in the feds is going to be able to get them to get around it. But it'll depend on what badge you're wearing. So if you're wearing a badge of a Texas officer, even if you're participating in that task force, you're not going to be able to go and you know, access this information of your own volition without a warrant under your own authority. If the Fusion Center shares it or some weird circumstance like that, this bill just can't. We can't get to that here, and trying might kill the piece of it that's going to affect the overwhelming majority of the cases. You know, we don't want to throw the baby out with the bathwater. So.
Here, Fred.
No,
The one other thing on this, I mean, ACLU does a bunch of stuff on this, and Greg Foster's an expert as well.
Yeah, he's our community advocate.
Yeah, so.
On the oversight board.
So I think on this question, you know, we're looking at trying to stop bad information from going, I guess, into the Fusion Center, right, from state and local police. I think that's, and so you're talking about kind of the federal to the Fusion Center, and that I think is actually, and I don't want to get off into this, but that's controlled more by the memorandum of understanding, and it's something that we actually might have local controls opposed to state control over. It's something that I think, you know, if you want to talk about it further, maybe me and Greg could chat about it, because I actually think there's always been potential to do a little bit more with limiting how feds share information into the Fusion Center here, and I'd love to chat about it.
Okay.
So, yeah.
Okay. Good.
Excellent.
Good job.
What are the key factors that you see influencing a positive outcome in the Senate? And how confident are you that if everyone here does their part in an optimal way, the way we all want to see it done, that there will be a positive outcome in the Senate?
Oh, well, I'm more optimistic about the Senate than I was last time by a long shot for a number of reasons. One, the senator who last time cut our amendment off of his bill and killed it and kept this from happening in the first place, lost his election and has been replaced by a man who is very much in support of this bill. And several other new senators, the freshmen, are supporters of this bill. Lois Kolkhorst, who is a rookie senator now, was a joint author, one of the top lead authors on this bill last session in the House when she was a House member. And add on to all that, we only have to get 19 votes instead of 21. And so, I mean, that's a big deal. I can't tell you how many bills I've had die over the years because I had 19 but not 21 votes in the Texas Senate. You know, given that we have several new allies, we have much stronger issue recognition among everybody, and the media has always been very much for us. I just see, you know, a lot of the stars aligned in the Senate. I mean, the House, obviously, if we can just get a darn floor vote, it's almost a shoo-in when you look at the numbers of supporters we have. And I think we'll get a similar number this time. So you're right that the Senate is the linchpin, but it looks as good as it's hard to project now, the Senate is a strange place. And nobody but the senators themselves, probably at the end of the day, truly understand how all of it works. And so.
Follow-up question. So the negotiations, the back and forth have been going on with the Houston District Attorney, who I'm sure is not the only person with an interest in negotiating some terms, right? Is that who it was? The
Yeah.
Houston DA? So,
He basically represents all the DAs.
okay, so it sounds to me like that's a really positive thing, reaching a compromise,
Right.
because they have certain, powerful sway as well. Assuming a compromise that is optimal for everyone isn't breached, it isn't broached before, looking for a floor vote, do you see that as an emergency situation, or?
There will be, we will peel off some opposition. I'm hoping that we successfully peel off the prosecutors. We're not gonna give them everything they want, so we'll see if what we give them is enough to peel them off. That said, we are in an incredibly strong position, and I don't necessarily feel the need to compromise everything. If I think they're right about, oh, this could cause some harm in this or this case, then okay, fine, but, we're in a position of power, especially in the House, and really just all told. Even the people opposing would say, yeah, you're probably gonna get it this time. So, we're gonna negotiate with the DAs. It is almost certain that a couple of the major law enforcement interests will continue to oppose it just to the bitter end, because they just don't want a warrant, period. And they always oppose getting a warrant for everything. And so they oppose it now because they always oppose it. And we're just going to have to beat them. And I think we're gonna have the votes to do it. And frankly, if they continue the tactics that they used last time, which were incredibly hostile and engaging in demagoguery toward this, again, 2/3 of the House members. So all of a sudden, when you start accusing them all of, all sorts of just terrible motives and, awful intentions, and, well, they don't like that. They wound up sort of being very isolated over how they behave surrounding this bill. And I think they're sort of at a loss as to how to attack it. So, well, I think we're in good shape, but again, we have to just finish the job. We have, 25, 30 new members in the House that she's gonna get to. We have a lot of people who this is, a new issue to. We have to make sure they're on board and finish the job before we're close. All right, well, thank y'all.